Hi, and welcome to the Trustcast show. And we're really happy to have on with us today Ryan Hancey. He's a trial lawyer for Kesler and Rust. And I had an intro all written up, but it wasn't quite exactly right. So I'm going to ask him about this. The case is really interesting. It was a 21-year-old who died of dehydration in a Utah jail cell, and the journey that he had to go through to bring the suit and ultimately prevailed. Awarding her family over $15 million. So maybe since I screwed up the initial introduction that I was practicing with you on, maybe you can tell me how this all transpired, the story.
Well, so I was sitting in my living room in December of 2016, and I got a call from at home from the father of Madison Jensen, the 21-year-old. And he was sobbing, and he told me he had just barely learned his daughter had passed away in the jail cell and was beside himself. So that's the first time I learned about the case. I immediately agreed to help him. And so, got back to the office the next day and we formalized that relationship. But I was in this case from the very beginning.
So tell me about, so how does somebody die so I know some of the details about this, but I'm sure our audience is interested. So how does somebody die of dehydration in a jail cell?
Madison went in with a condition. She was withdrawing from opioids. And so I'm guessing that she was already in a weakened state, although when they brought her to the jail, she wasn't showing any symptoms. But she got to the jail, I want to say at 5 o'clock in the afternoon, and that night a guard saw her throwing up. And so the symptoms started pretty quickly after her arrival. And when we marched through the story at trial, if you were to hear it, you would see that every day that progressed of the 5 days she was in jail, her condition continued to deteriorate because she wasn't able to take in fluids. And so the combination of not being able to keep down fluids and the lack of medical care is what caused her to dehydrate and pass away.
So tell me about the case and how it transpired, because I think that this part is interesting. So from the time that 2016 until you had the final judgment, how much time lapsed in between there?
Almost 9 years. Got the case, and she died in December of 2016. We went to trial in April of 2025. So yeah,
So
long time.
so so I want to dig in there and get to the details, because some of this I think is extremely interesting, and that you had to have some dogged determination to make this all work, and your client obviously had to be determined as well. So tell me about that journey. I just think this is an interesting case, deserves a little bit of attention.
So we initially filed the lawsuit, I think in 2017, and we brought in a bunch of defendants. I would categorize them into three groupings. You had Duchesne County and the sheriff of the county. So that was sort of those were the municipal defendants. You had the medical people. So you had the contract doctor and his physician's assistant, and then the nurse that worked at the jail. Those were the medical defendants. And then you had a grouping of jail guards who were the ones that were, checking cells and working or interacting with Madison on a daily basis. And so that's how the case started. We conducted discovery. I think all of the defendants filed motions for summary judgment. And, years ago, the district court judge decided, I think he decided that it was the medical people's fault. He let out the municipal defendants and he let out all of the jail guards. And so we were now in a position where we had three defendants left in the case. They were the doctor and the nurse and the PA.
So tell me about the conversation with the family. I want to kind of get in. At that point, you're, the one group with the really deep pockets had
Right.
just disappeared from this from the lawsuit, and you had to kind of prepare them, hey, this is not going to be what you think it is, or I imagine a conversation like that.
I never had that conversation because the case really wasn't about the money ever. It was about something completely different. It was always about vindicating Madison's life and making a wrong right. You know what I mean? Or
Yes.
making it as right as it can be after the fact. I mean, we can't bring her back to life, but something needed to be done to address the situation. And so I never had that conversation. We rarely ever talked about money, and
Yep.
what we wanted is to have her day in court.
Yeah. And if you have a family, you really appreciate that sentiment. If you lost
Yeah.
a child, money doesn't mean anything in that
No,
scenario.
no.
So okay, so now you're back in court. Now you're down to these three defendants, and then what happened?
So two of the three defendants that were left in the case filed an appeal, and the this is one of the things I like the least about the law. Okay, but the government defendants have a right that no one else has. No private citizens like us get this luxury, which is they get to file an appeal of decisions they don't like or rulings they don't like before trial. We all have to wait until there's been a trial or an adjudication of the case on the merits and there's a final judgment in place. Only then can we appeal. It could be on something that happened 6 years earlier, and so it's a real advantage, and the government takes advantage of that because they have the resources and it's in their playbook. And so two of the three filed an appeal. They know it's going to take 2 years. They're hoping, I think, it takes the wind out of your sails. Went up to the 10th Circuit, and the 10th Circuit agreed with one of the medical defendants, let the doctor out, disagreed on the nurse. So that was sent back to the district court. And now we were going to trial with the nurse and the PA. So we had two defendants, and they were both individuals. And trial, was coming up relatively quickly. So that was the next thing that happened. And so we were facing this task of going to trial against two people. We filed a motion for reconsideration. We found some case law that supported the proposition that the county's dismissal was improper, or they shouldn't have been dismissed. We presented those arguments to the court. The court agreed with us. Now
So was
county
this
is
the
back in.
same judge that was involved in the initial decision that when you or I mean when in the initial dismissal, was it the same judge that was involved, or this is a whole new judge that you're discussing with?
It would have been the same judge, except that during the pendency of the appeal, the original judge retired. And so, or went on, I think he retired. And so we had by the time the case came back to district court after the appeal, we had been assigned a new district court judge. And it was that judge, Judge Barlow, who granted our motion for reconsideration. So now, like I said, county is back in, and we're on fast track to trial with the three defendants.
Wow, that was quite a change.
It was huge, right? And it was the right thing. I mean, I think that Judge Barlow got it right, and it was I think it was a brave opinion, and it certainly strengthened the case, or at least the ability to have a jury look at what happened and say, okay, we don't really have sympathy for a county.
Yeah. So tell me about the case law that you used and how you found that case law and how you applied it to this individual's situation.
Well, so when you're dealing with these civil rights cases, it's an uphill battle for a plaintiff. It's really hard to get to trial against a municipality, and one of the things you have to show is that there are cases that have a ruling or a holding that would have put these defendants on notice if they had read the case, hypothetically, that what they did was wrong. And In this particular case, we found a case that was in our circuit where it involved a medical issue. The allegation was that a person in jail hadn't gotten treatment, that the medical people knew about it. They didn't get him to a doctor. They kind of laughed at him, and he sustained some, serious injury from because he didn't get treatment quickly. And in that particular case, the 10th Circuit panel had found that you could find you could go to trial if there was a systemic failure on the part of the jail as a whole. In other words, you didn't have to point to the misconduct of just one individual, one jailer, the sheriff, any one person. It could be a collective environment in which the failing was so bad that it was almost obvious that something of this nature was going to happen eventually, and did happen. And that was kind of the standard that we advocated for, and Judge Barlow agreed with us.
That's very interesting. It's interesting to me. We do have a lot of lawyers who listen to our podcast, so I'm sure that there's going to be a group that finds the story interesting as well. So I'm going to switch gears a little bit. So other than that, did that go to a jury trial, or was that a judgment in front with just a single judge?
We had a jury panel of 10 people.
Okay. Wow.
And they returned a verdict. I think it took them, maybe 6 hours.
Wow. That's amazing.
Yeah.
Yeah. Great job. So, you typically, you've been trying cases in Utah for over 24 years. And typically you're doing trial work, as I understand, and you're working with other outside attorneys. Is that right? That's the research that I have.
Well, if you're referring to a statement on my LinkedIn bio, where I invite people to collaborate with me on cases that they have, that has happened from time to time. I usually am going to trial with members of my own team here at Kesler and Rust. I've got amazing trial lawyers here, and our teams usually handle the case ourselves. But I've litigated cases in other states where I'm not licensed, and in those instances, I have to get admitted pro hoc vice, and I have to find a local sponsoring attorney, and we've teamed up in that capacity. And I've had other people who have cases here in Utah from other states, and we've collaborated in that way as well.
So you've won jury and bench trials in construction, defamation, breach of fiduciary duty cases. What ties all those wins together?
Yeah, it's this. A lot of lawyers will say to you, they have a specialty, right? Their expertise is in construction law or in real estate or whatever else. I like to think, and I'm sure there are other lawyers who think like I do, my expertise is not so much in a practice area, although, there are some areas that I know more about than others, but it's more really in litigation and the process. It's in getting a case in through the door and getting it ready to go to trial, and all of the things that happen in between A and Z. There's a lot of strategy, there's a lot of decision making, there's a lot of things that go into getting yourself positioned where you can have success at trial. And what I found is that it doesn't really matter so much what the issues are in the case, or what I mean, if it involves real estate or construction or civil rights. I mean, that matters to some extent. You have to know the law, and you have to become an expert in whatever that case is presenting to you. But in a way, it's sort of plug and play too, because if you have a litigation system that's really good, and you know how to go from you know what you need to get to be ready for trial, then that system is going to apply to whatever issues the case presents. And so I'll just give you one example. Several years ago, I had a jury trial in federal court. It was a products liability case, and my clients were mink ranchers. weirdly enough, there are 2 states in Utah where I guess the climate is perfect for raising mink, like for mink coats. And it's Utah and Wisconsin for whatever reason. And so these guys had a mink farm. They purchased feed for their mink in bulk and started feeding it to their animals, and thousands of them died. They almost their ranch got decimated. And so the issue was the feed poisoned? How was it poisoned? Was there a causal link between, did the company know? And all those issues were presented in the case. I knew nothing about mink ranching, but by the
Right.
time we went to trial, I like to think I could have opened up my own mink ranch. At least I knew the terminology, you know what I mean? And I knew the breeding cycles and all that minutia that made the presentation of the case a success. And you learn it because you need to. And that's kind of why I'm able to try cases of all types. And I frankly enjoy it because the variety is challenging and fun.
So Ryan, when you do take on a variety of cases, I would imagine limits your ability to take on. So when I think of a big law, big law, they're run their team ragged, with multiple cases at a time, and 80-hour weeks are considered part-time. Uh, In your particular instance, when you're working with all this variety, how does that affect your ability to take on new clients at times?
It hasn't had any impact on it at all. I have a steady flow of clients coming through the door, and I have, like I said, an amazing team here that is by this point used to the variety that I present. And so I'm hoping to be able to say that I've mentored them into having the same mindset I have, which is you can handle any type of litigation case for the most part. There's some excluded categories that are too specialized, but you can handle a broad array of cases if you really know how to litigate. And so I'm exposing them to all types of cases, and they're really, really good. And that's how we're able to go up against anyone, or it doesn't matter the size of the firm or the size of the party on the other side. We've seen it all, and we've had good success.
So tell me about the breach of franchise agreement case that ended in a six-figure verdict. What turned that?
So that was some time ago, but I'll tell you my most prevalent memory from the trial, because it was a jury trial. And there was a point when I had the main defendant on the witness stand, and the courtroom was set up in a way where I was just a few feet away from the jury. The jury was, of course, watching the witness. My back was to the jury, sort of, but my partner was watching the jury. And so I was doing the Q&A, and the defendant was sort of copying an attitude. In my opinion, they were being a little bit smug, a little bit snarky, maybe is a better word. And and so that got me riled up a little bit. And at one point, I remember he gave an answer that he couldn't have possibly known, like something that was going to happen in the future was completely speculative. And so I just couldn't help myself. And I asked him if he was a mind reader. And he looked at me right in the eye and he said, yes. And I didn't get to see this, but my colleague who was watching the jury said their mouths fell open and their eyes sort of rolled. And yeah, they returned the verdict.
This, it never fails to amaze how someone can just step right in and just Anyway, so what's the case that you lost or almost lost that you feel like taught you the most in your career?
So the last case I can remember, um, it was a tough loss. It was in 2018, maybe. And the challenge in that case was, ironically, my own clients. Um, I pride myself in over preparing for trial. And part of that process is making sure that your own clients are going to testify well at trial, that your Q&A with them on direct examination is going to go smoothly, flow well, that they, I'm not coaching them, that they can listen to my questions and they know what I'm trying to get at and they can answer the questions, and then that they're ready for cross-examination, which includes body language, comportment. Don't be that smug person. Look the lawyer in the eye, be respectful. Even if you feel like they're taking a shot at you, be the bigger person, because the jury is watching that exchange and the jury is making judgments about your character. And even if they like the other lawyer, but they see that person, in their view, bullying somebody on the witness stand, and they're putting themselves in the shoes of the person on the witness stand, thinking, oh my gosh, what if I was up there and this guy was asking me these questions? It would be infuriating. And so there's a sympathy factor. And so we go through all of that. And as we got closer to trial, I brought him into my conference room, and I had, we started going through the Q&A to kind of get them ready. And I mean, the first time was a train wreck. They weren't listening. I mean, we were practicing cross-examination. So yeah, I was asking some tough questions I thought might be asked at the trial, but they were not listening to my instructions about keeping cool and looking me in the eye and answering my question. And look, if you have to concede a bad fact, concede it. It looks worse when you don't. And so it was a train wreck. And at the end, I was like, okay, that's not going to work. And here are all the things we've got to work on. So let's run it back. And so we did it again, train wreck. So I said, okay, you guys need to come back in a couple of days. We need to work on this, because I can't have you being on the stand at trial in front of a jury with acting like that. You have to tone it down. And so they came back, and a long story short, I'll bet we went through those questions a dozen times. I don't know how many times, a lot. And by the last time, it was a slight improvement. So I was like, okay, I guess this is what I'm going to get at trial, but it's better than what I started with. We went to trial, and I did my Q&A, and they were just fine. Then the other lawyer gets up and starts the cross-examination, and it was a dumpster fire. It was as bad as it was the very first time, and we lost the case. And one interesting insight that I'll share is that after the trial was over, I got a phone call from one of the jurors, and they wanted to meet with me. And so they came to the office, and we had a nice chat. And the jurors said, I just want you to know that if I needed a lawyer, I would hire you, not those other lawyers. And you did a great case, and we appreciated that. You could tell that you worked hard and that you were very professional, and and so forth and so on. But we didn't care for your clients. We didn't, you know what I mean? And that's
Yep.
that's why we had to decide it the way that we did. So it's not a reflection on you. And they wanted to make sure that I knew that, and that made me feel good. But the lesson, or the takeaway that I got from that experience is something I already knew. I guess you have to be prepared. It underscores the importance of that. Like, you've got to make sure your clients are ready to go. But if they're not, maybe it's time to have a settlement discussion, because you don't want that happening in front of a jury.
Mm-hmm. Yep. That makes sense. So the Jensen case reached a cert petition at the U.S. Supreme Court over qualified immunity. Walk me through that fight.
Yeah. So the I have to confess, I wasn't much involved in that because I got a phone call from a law firm back east who specializes in these types of appeals and in arguing in front of the Supreme Court, and they graciously offered to take up that fight pro bono. And
Hmm.
so
Wow.
they were the ones that handled that, and they would just kind of fill me in on where we were. It didn't make it all the way to the final cut, unfortunately, but so that's really my firsthand knowledge about that process.
Okay. So you've handled everything from products liability to landlord tenant disputes.
I have.
How do you decide what goes to trial versus what gets settled? That's a big question. That's, I mean, there's not one way, but how does that equation play out in your mind?
Well, a lot of times it's not something that you can control. Just take the Madison Jensen case as an example, okay? Because it's going to be the same for every case. If you're representing a plaintiff and you believe the plaintiff is entitled to some money, and the defendant doesn't make an offer, they won't put any money on the table. Well, your choices as a lawyer are either to go try the case or withdraw as the attorney. There isn't really a middle ground. You can't force someone to make a settlement offer, right? And so uh, in that scenario, it's easy because, first of all, I'm not going to take a case that I don't believe in. And so if they're not going to put money on the table, I'm going to see it in court. That's just the way it is. Now, the closer calls are when they put money on the table, the other side does, and your client wants more. So then the math changes, right? It's more like, is it worth going to trial for the possibility of getting your number or maybe higher, but also the risk of losing and getting nothing? And clients always like to hear, well, give me the percentage odds of winning or whatever, and I so I'm not doing that. Like nobody can know that. And anybody who tells you your chance of winning is 80%, you know what? Maybe go have them represent you, because I don't believe that. Like that's not how it works. And so, like, you can lose cases that you should have won and vice versa, right? Everybody knows that. And so and judges and juries are unpredictable. So but that's really not a thing. But I'll just say, look, I like your case, but there's always a risk of losing. If they're drawing a line in the sand at a number that's lower than what you want, you've got to decide, client. This is my recommendation, but you have to decide if you're willing to live with that or not. Sometimes not sometimes, almost always, I have a pretty good feeling of whether or not a bottom line number is really a bottom line number, right? A lot of times those words are thrown around, and there's more negotiations to be had. So, but I like to tell my clients, do not make an offer. Don't communicate, this is my bottom line number, if it's not, because I don't like gamesmanship in litigation. And I like my reputation to be that I do what I say. And so if I say this is the final number, that should be your final number. And because then otherwise I think you lose credibility. And so and you lose credibility if the other side knows that you're not going to go to trial. Then you lose leverage, right? You lose leverage if you're not known as somebody who will take the fight all the way to court if you need to. And so I think those are the things that factor in. I don't know if I answered your question, but it's not the same formula every time. You really have to read the room and consider the circumstances of the particular case.
So what do you want Kesler and Russ known for in Utah legal circles?
We should be a go-to litigation firm. If you need a firm who will fight for you, who will go all the way to the mat, all the way to trial, and we will communicate with you. We'll have your back. We will do everything the right way, and you're going to have a good chance with us. I mean, like, we will do whatever it takes. But you're not also going to be billed at the big law rates. I mean, I'm not saying that we're cheap or inexpensive, but we don't have the overhead those guys have either, right? And so we're a small boutique team, and we're really, really good at what we do. And so if you want personalized service and excellent results, I think that that's what we offer.
So Kesler and Rust. So you're the litigation director in a firm that is a litigation firm,
Right.
but your name's not on the door. Can you tell me how all that works without disclosing all the internal stuff, or just so that people understand? I don't know. It's just a point of conversation.
No, of course, no problem. So Kesler and Rust was formed in 1980 with V.L. Kesler and Joseph Rust. By the time I joined the firm as a law clerk in 2000, V.L. Kesler had long since retired. So I've only met him from time to time because he'll pop in and say hi, but I never worked with him. Joseph Rust stayed on until maybe 10 or 12 years ago, and then he retired. And so neither of those guys have been at the firm for a long time. There were two other lawyers who were more senior than I who have retired in the last 3 or 4 years, and one as recently as December. And so just by luck of the draw, I'm now the most senior person at the firm, and I don't consider myself that old. Yeah, so that's how that's the history of the firm. And I suppose that the guys that are working here now, could be of the mindset that we should have a name change, but that's never really been important to me. I'm not driven by that. I feel like Kesler and Rust has been around for a long time, and it has some, it's known in the community, and it has some value. And those guys founded the firm, and it's their legacy, and I feel like that means something. And so I have no desire. I haven't even thought about changing the name, really.
Yeah. So there's plenty of firms that have been around for 100 years or more that have the original founders' names on them. So that's not an unusual thing. So tell me about what you see over the next 5 or 10 years, or the direction you see your firm going in.
Yeah, that's a great question, because one of the long-time questions, at least at this firm, I think, is how much do we want to grow? Because there's some benefit to being small, but there are also some limitations. And so, do we want to take on more new hires? Do we want to sort of bring somebody on when somebody retires? And so that's been a constant discussion, right? And I think that in the next 10 years, where I see the firm going is that we're going to grow a little bit, but that we're going to be taking we're going to be taking great cases, and we're going to be, we already have just a grouping of amazing clients. And I don't see any of that changing. I think that in our firm, and also globally in the legal community, it's going to be necessary for the lawyers to embrace, to some degree, the use of AI in the practice. And I'm sure, you talk to lawyers all the time, of those stories where lawyers have gotten sanctioned or fined, right, for including hallucinated cases in their briefs. And so, we have measures in place to make sure that doesn't happen. Everybody here knows that's not going to be the research source without human eyes being put on every single thing that we cite to, and it better be accurate, right? But I've also seen in the short time we've been using it that it can really, really help cut down on the time and hassle of what are really administrative tasks. And so you're able to streamline many aspects of cases in a way that's really helpful and frees up your time for maybe some of the more important aspects of the case.
So how do you find um, people to bring into your firm, your legal staff, other lawyers, either young people and develop them or experienced people? How do you attract them into your firm, and then how do you develop them?
Well, so generally speaking, our we have not been interested in hiring laterals. We typically like to pull people from law schools and then mentor them ourselves and train them in the Kesler and Rust way. I think that that's been very successful. Some of our best people, and you should understand, I mean, most of the people that work here have been here for a long time. It's a great place to work. And so people don't leave, or the ones who have, they don't last very long. And so the ones that are here right now have all been here for a long time, or at least out of law school. And so, and some of the people that we have right now have been referrals from other people that work here. And so like that's been a very good system. The way that we train them is, if you come work for us out of law school, you're going to be essentially jumping into the deep end of the pool, right? Because we're being a small firm, it's not going to be a scenario where you're just doing legal research day in and day out for 2 years, the first 2 years of your practice. No, you're going to be preparing deposition questions. So at least the first draft, you're going to be writing briefs. You're going to be interacting with clients. You're going to be doing a variety of things, and you're going to sort of learn through a baptism by fire process. Obviously, there's going to be supervising attorneys that are watching and monitoring, and then jumping in and training and saying, look, these are some things that you can improve, or here's some things that we saw that aren't the right way to do it. And so then so they're learning, and then the next time they don't make that mistake. And that's why everybody here is an excellent litigator, because
So
yeah.
no, I'm jumping into a completely different thing. So my son lives in Salt Lake, and I go there from time to time, and I noticed that on the freeway there are a a million billboards for attorneys.
Right.
Um, I mean, just a million. How do you? Uh, it seemed like an inordinate amount. How do you bring in new clients? What's your favorite way to bring in new clients or make them aware that you're out there?
Well, are you talking the firm or me personally?
Either or both.
Yeah, I mean, so I've been fortunate to have been referral based 100% for years and years. And I would say the majority of my new clients, it helps to not lose clients, right? It helps to have clients for a long period of time that just stay loyal because you've done a good job for them. And so there's, that base stays. But as far as new clients coming in the door, I would say that the largest source of that would be either client referrals or attorney referrals. And a lot of those referrals come from counsel that have been on the other side of a case from me, which I think speaks to the professionalism in our community, and how that can, and how you should be cordial to your opponents, and practice law the right way. Because if they have a conflict or whatever else, and they thought that you did a stand-up job, you might get a call and say, hey, can you help this person out that I can't help out? And so those have been wonderful sources, and a way to keep everybody at the firm busy.
So if someone is listening to this now and they say, they're in you practice in Utah, any other areas that you practice in?
Well, our firm is located in downtown Salt Lake City. I have I have litigated cases in other states, but I would say the vast majority of the cases that we handle are in state or federal courts in Utah. Right now,
So
I'm
if someone's
litigating a case in Delaware. I have a new matter up in Idaho. I've done Colorado, Wisconsin. I mean, I've done several states, but Utah is really the hub.
wow, that's impressive. I think you did a great job on the show. I really appreciate you coming on. So if someone is interested in getting in touch with you or your firm, what's the best way to do that?
Yeah, call the main number, 801-532-8000, and you can ask for me, and somebody will put you through. You could email me. It's rhancey, RHANCEY, at KeslerRust.com. That's spelled KESLERRUST.com.
Okay, thanks so much for coming on, Ryan. I really appreciate it.